Tantor Audio, a division of Recorded Books, presents Virtual Searches, Regulating the Covert World of Technological Policing by Christopher Slobogin, narrated by Peter Lerman. Preface. This book is a sequel of sorts. In 2007, I published Privacy at Risk, the New Government Surveillance and the Fourth Amendment, which summarized my thinking on how the Fourth Amendment's prohibition of unreasonable searches and seizures might apply to government surveillance. In this book, I continue to subscribe to the 2007 book's argument that all types of surveillance are Fourth Amendment searches and that they must be authorized by justification proportionate to their intrusiveness. But technological, legal, and political developments have since conspired to require a significant update of Privacy at Risk's central message, as well as a new focus on sub-constitutional means of regulating government use of technology. On the technological side, government's capacity to monitor its citizens has increased exponentially since 2007. Privacy at Risk talked about camera surveillance and drones, thermal imaging devices and beepers, data mining and digital dossiers. But this book will add into the mix facial recognition technology, automated license plate readers, cell phone tracking, and geofencing techniques, as well as familial DNA matching, predictive policing using algorithms, and government contracts with data brokers. All of these investigative practices have become routine since I wrote Privacy at Risk. A recent survey found that even many small police departments make use of cell phone tracking technology, and that between a quarter and a third of over 200 departments queried employ drones, CCTV, closed-circuit television, and automated license plate readers for various purposes. Legal developments have been even more dramatic. While much of the technology just mentioned existed at least in nascent form in 2007, Fourth Amendment jurisprudence was still in a pre-technological Stone Age, wedded to a concept of police searches that focused on physical entry of houses, papers, and effects, and barely acknowledging the vast increases in data acquisition, storage, and analysis capacity that computers have brought. But in three decisions handed down in 2012, 2014, and 2018, the United States Supreme Court finally began to acknowledge that police access to tracking technology, data in phones, and data collected by private companies warrant constitutional regulation, even when the information thereby obtained was technically exposed to the public or voluntarily surrendered to another private party. These cases mark a sea change in Fourth Amendment law. Legal developments outside the courts have been at least as significant. Federal, state, and local legislatures have increasingly flexed their regulatory muscle in this area, with the result that there has been a significant upsurge in statutory treatment of surveillance technology as well. Perhaps that is in part because the politics relevant to technological policing have also seen momentous change. Most importantly, in 2013, Edward Snowden famously leaked mountains of documents about America's national security surveillance programs. Almost overnight, it seemed, both the general public and the private companies that had facilitated those programs became noticeably more hostile to surveillance, no doubt in part because memories of the disaster on September 11, 2001 had faded. In the more recent past, the politics around policing has also undergone a transformation. The murder of George Floyd and the rise of the Black Lives Matter movement in particular have made the public more attuned to the power police wield and their willingness to abuse it. For all of these reasons, the time is ripe for a new book about what I call virtual searches, police investigatory techniques carried out covertly, remotely, and technologically, rather than through physical intrusion. Despite the Supreme Court's signals that it is rethinking how the Fourth Amendment applies to virtual searches, the case law still tends to give law enforcement quite a bit of leeway in this area. In contrast, most scholarship has tended either to demand strict regulation of new virtual search techniques or to call for their outright abolition, both on general privacy grounds and because of the impact of surveillance on racial minorities. This book stakes out a middle ground in fashioning legal responses to technological policing. It tries to take into account the implications of new technological developments, the burgeoning judicial interest in expanding Fourth Amendment protections, and the rejuvenation of libertarian and anti-racism politics, without losing sight of the fact that crime, especially violent crime, is a serious problem in this country. This book also takes a broader view of regulatory alternatives than did Privacy at Risk. That book focused on the judiciary as the main driver of surveillance regulation, and thus was mostly about the interpretation of the Fourth Amendment and other constitutional provisions. While this book also devotes considerable space to analyzing Fourth Amendment jurisprudence in the hopes of shaping its future contours, it is more attuned than the previous book to the potential of legislatures and other representative bodies to devise means of curbing government power. Whether or not the Fourth Amendment is read as broadly as I contend it should be, the precepts set forth here can inform the legislative and agency policies that we are beginning to see promulgated in much greater numbers than a mere decade ago. Virtual Searches was essentially written from scratch, although parts of it borrow from articles I published in the Georgetown Law Journal and the University of Pennsylvania Law Review, and chapters published in the National Constitution Center's A 21st Century Framework for Electronic Privacy, and the Cambridge Handbook of Surveillance Law. 1. The legislative struggle over virtual searches. The third week in January 2021 saw three developments in the law governing technological policing that cemented the decision to write this book. None of the developments was earth-shattering. In fact, all three were fairly typical, but that's the point. The three events occurring at the local, state, and federal levels are representative of today's daily ferment over what I'm calling virtual searches. 1 week in January 2021. The first event occurred in Nashville, where I live and teach. In January 2021, Nashville, like the rest of the country, was in the midst of the COVID-19 pandemic, and the city was busy figuring out what to do about it. But on the night of January 13th, the focus of the Nashville City Council's Committee on Public Safety, Beer, and Regulated Beverages was automated license plate readers, ALPRs, cameras that can record license plates and, in some versions, much more. Several years earlier, the Council had passed an ordinance that prohibited operation of ALPRs installed onto or within the public right-of-way, unless they were used to help identify vehicles suspected of involvement in a crime or violating emissions standards. Then, in the fall of 2020, Councilmember Freddie O'Connell proposed an amendment that, while leaving the criminal investigation and emissions exceptions in place, would otherwise have prohibited operation of ALPRs to capture occurrences on public spaces, no matter where they were installed, a provision that many thought would apply to the use of Ring doorbell cameras and other privately owned devices that might pick up street activity. That proposed amendment prompted counter-proposals, supported by the Metropolitan Nashville Police Department, that would have expanded permissible use of ALPRs to collection of license plate information, even if, at the time, it was not pertinent to an existing criminal investigation, with a proviso that the license information had to be destroyed within 30 days unless it turned out to be evidence of a criminal offense or a civil traffic or parking offense within that period of time. Given the ensuing controversy, there were also calls for public input on the issue. Thus, the Committee on Public Safety, Beer, and Regulated Beverages, chaired by Councilmember Jennifer Gamble, held a number of open sessions seeking input on the use of ALPRs, including the one I attended on January the 13th. I was there, actually in the Zoom room, only as an interested observer. I had testified at a previous meeting of the committee, but had not taken a position on any legislation. Rather, I had described the likely impact of the Fourth Amendment's prohibition on unreasonable searches and seizures on surveillance of public thoroughfares. To sum up the gist of my testimony in a word, none, for reasons explained in later chapters. I'd also noted that a number of jurisdictions had policies regarding ALPRs, and that the typical statute or regulation identified the specific types of incidents that could be subject to surveillance and required policies governing the retention of, access to, and security of any information collected. One of the other principal speakers at that hearing had been the chief of police in Belle Meade, a suburb of Nashville, who testified that in the 2 years after installation of 19 fixed ALPR cameras in his jurisdiction, burglaries had decreased by 50%, and arrests for stolen vehicles and license plates, all from areas outside Belle Meade, had increased from 1 to 41 compared to the 2 years prior to installation of the cameras. The January 13th meeting, held a month later, was principally meant to solicit comments about government use of ALPRs from public interest groups rather than experts, as well as look at the newest version of a bill authorizing greater use of ALPRs. The first several speakers, while members of the public, also sat on the Metro Human Relations Commission, a 17-person body appointed by the mayor with the goal of promoting one city for all people. All of them were against expansion of fixed ALPRs, and a couple indicated antipathy even toward the relatively common practice of mounting ALPRs on police cars, where they could signal police whether a license plate was on a hot list, indicating that the car had been stolen or used to commit a crime. The first of these commission members focused on trust issues. She contrasted law enforcement's push for ALPRs with its foot-dragging on the city's policy regarding cameras on officers and squad cars that could record police-citizen interactions. In her view, ALPR surveillance is antithetical to community policing and building relationships with the community because of its constant monitoring of activities that would usually otherwise go unnoticed. Although she noted that a small online survey of Nashville citizens had found some support for ALPRs, she dismissed those results, arguing that the questionnaire was an inelegant and inadequate means of ascertaining community sentiment, especially given the likelihood that many groups are not easily contacted through the Internet. She also objected to ALPRs on the ground that the data they collect are often funneled through private companies that are difficult to monitor, and that can use the information for their own profit-oriented ends. She ended with speculation that cameras would be placed and the data used in ways that would harm disadvantaged communities. The next member of the commission who spoke, a Vanderbilt University professor, picked up on this last thread, contending that ALPRs would do nothing to fix a society full of inequities. Black and brown people will be disproportionately targeted by ALPR technology, he predicted, and that development will exacerbate differential treatment by the government. For instance, the professor suggested, ALPR data will likely be shared with Immigration and Customs Enforcement, the federal agency known as ICE or ICE, charged with enforcing immigration statutes, or used to surveil people who attend mosques. Further, if ALPR data is maintained for the government by a private company, it will be aggregated and shared nationwide in ways that local legislation passed by the Nashville City Council could not affect. If instead it was maintained by the government, data could be exploited by political opponents or jealous lovers. Even limiting ALPR use to real-time hot list alerts with no additional recording capacity would not prevent abuse, he concluded, because hot lists can be wrong. The speaker who followed headed the Nashville chapter of Neighbor to Neighbor, which, in its many manifestations around the country, attempts to represent community interests and harness the power of local residents to address local problems. Based on his reading of the polity, he too said that many people are not sure the government can be trusted to protect their civil liberties. At the same time, this speaker asserted a large group of those he informally polled were concerned about property theft, especially so-called porch pirates who steal packages, drag racing, drug sales by gangs, and violent crime. He noted that at least one neighborhood had installed cameras at its own expense in the belief that surveillance could help with these problems. However, the next several speakers, like those from the Human Relations Commission, were not convinced that ALPRs were worth it. One was concerned that the Civilian Oversight Board recently established to monitor Nashville police conduct had not been asked to examine any of the proposals. The board has since come out against expansive use of ALPRs. Another noted that unless the state legislature enacted an exception to its public records statute, ALPR data in government servers would be available to anyone who made a proper request. A third pointed out that even if camera data is encrypted or sequestered in some other way, law enforcement could obtain it through a standard subpoena, which is much easier to obtain than the warrant mentioned in the Fourth Amendment. And a fourth speaker, apparently not privy to the Belmead police chief's presentation to the council the previous month, opined that there had been no concrete showing connecting the dots as to how ALPRs in Nashville would detect or deter crime. Nor was there any information as to how much an ALPR system would cost, or who would decide where ALPRs would be placed. Then, toward the end of the meeting, two members of the city council itself spoke up, and their comments clearly pushed the other way. The first, the only black person on the schedule other than Gamble, the committee chair, represented a district heavily populated by people of color. She asserted that a majority of her constituents favored use of LPR-type systems given concerns about drag racing, stealing, and violent crime. We don't have enough patrols. We need more assistance. ALPRs, she said, could make up for unequal police coverage. I have Ring. There's a lot of sharing of Ring data and other security systems that folks have. An ordinance that banned this kind of surveillance, she claimed, would be rejected by an overwhelming proportion of her district. The second council member, a white woman who represented a very diverse jurisdiction, echoed these sentiments. I get calls wanting more patrols multiple times a week, and as I've met with different nationalities and races, I've seen that the immigrant population is victimized more times than not because the perpetrators know their victims are scared of deportation and won't call the police. Cameras, she contended, would make communities safe for everyone and do not have racial bias. They rule out innocent people. She ended by saying, I'm really passionate about this because I want to make my community safe for everyone, and I think there is a way for us to do this, while providing a robust framework for auditing and reporting procedures. The kind of debate Nashville is having about ALPRs is far from unique. Battles between those who think technology might help keep us safe and those who suspect it will not, between those who are relatively sanguine about technology's impact on privacy and those who believe it will exacerbate racial tensions, lead to police abuse, and increase the scope of the police state, are occurring all over the country, not only in local venues such as Nashville, but also at the state and federal levels. In fact, just a few days after the Nashville meeting I attended, State Senator Becky Massey introduced a bill in the Tennessee legislature aimed at amending the state's drone surveillance statute. The previous Tennessee law on drones, enacted in 2013, carried the lofty title, Freedom from Unwanted Surveillance, and was passed during a national wave of similar statutes. It required police who wanted to use a drone to obtain a warrant from a court, except when there was credible intelligence of a terrorist attack by a specific individual or organization, or when there was reasonable suspicion that the drone was needed to prevent imminent danger to life, or search for escaped felons, missing persons, or evidence relating to accidents, crimes on public property, or fire. Some privacy advocates resisted even this relatively restrictive approach, expressing concerns about the further militarization of our civilian police forces and the possibility that drone usage could lead to fishing expeditions and invasive, all-encompassing surveillance that could seriously erode our privacy rights. Many law enforcement officials, in contrast, wanted more expansive authority to use drones, including in their campaign to discover illegal marijuana fields from the air. Senator Massey agreed. Her amendment sought to change the law by allowing warrantless drone usage to investigate the scene of any crime, regardless of where it was committed, and by extending the time that images collected by a drone could be maintained, from 24 hours to 30 days. The amendment eventually passed both houses of the Tennessee legislature and was signed by Governor Bill Lee in May 2021. The battle has also been joined at the federal level. The BREATHE Act, a proposed federal law introduced in 2019 by several members of the United States Congress and supported by citizens groups such as the Movement for Black Lives, would prohibit all federal spending on aerial surveillance, facial recognition technology, predictive policing algorithms, or any tool used to collect biometric data. Yet the Commercial Facial Recognition Privacy Act, proposed in Congress the same year, while in most cases requiring explicit user consent before facial recognition data may be collected, specifically exempts from its provisions use of facial recognition technology if intended to detect or prevent criminal activity, including shoplifting and fraud. Similarly, the proposed Federal Privacy Bill of Rights, introduced in 2019, would require all commercial enterprises to indicate the purposes for which personal information, broadly defined, is collected, and to obtain affirmative consent from the customer for any alternative use, but would still permit non-consensual sharing of this information with law enforcement pursuant to a court order. That gets us back to the week of January the 13th, 2021. 2 days after the Nashville hearing on ALPRs and a day after Massey sent her bill to the Tennessee legislature, U.S. Senator Amy Klobuchar of Minnesota introduced in Congress a bill to protect the health data of all Americans. Proffering a similar bill 2 years earlier, Klobuchar had stated, "New technologies have made it easier for people to monitor their own health, but health tracking apps and home DNA testing kits have also given companies access to personal private data with limited oversight." The intent behind the legislation, she explained, is to protect consumers' personal health data by requiring that regulations be issued by the federal agencies that have the expertise to keep up with advances in technology. But the current version of the bill, like the Consumer Facial Recognition Privacy Act and the Privacy Bill of Rights, also states that any regulations that are promulgated under it should take into account differences in sensitivity between genetic data, biometric data, and general personal health data, the needs of researchers who use such data, and, most relevant to this book, the needs of law enforcement. Virtual searches, legislatures, and the courts. The three bills introduced during a single week in January 2021, involving ALPRs, drones, and health data legislation, are emblematic of the struggles cities, states, and the federal government face in deciding whether and how to deal with the relatively new phenomenon of technologically enhanced searches by law enforcement. Traditionally, police investigating crime engaged in physical searches of property or visual observation of someone's travels and transactions. Today, police are just as likely to resort to surveillance and data acquisition procedures that do not require physical intrusion, but rather can be carried out virtually from headquarters or even a squad car. Without ever leaving their computers, police can access feeds from ALPRs, CCTV, and drone and satellite cameras that can both capture images of our public activities in real time and maintain a record of those activities, data that can then be used to track people's movements or compared to hot lists and facial recognition data banks. An even greater information bonanza exists in the cloud and other cyberspaces because every aspect of our daily experience, communications, financial transactions, and even our health needs are datafied and stored under the auspices of our credit card company, cell phone carrier, internet service provider, or some other third party. Even activities inside the home are vulnerable to virtual searches. Unless users save their activities only on their hard drives, everything they do on a computer sits on a third-party server that can be accessed by the government, usually with a subpoena and often simply upon request. With the right equipment, law enforcement can, unbeknownst to the user, activate the computer's camera and monitor the keys being typed. Phones can be hacked, cloned, or turned into microphones. And those helpful, friendly devices known as Alexa and Echo can record every word spoken within range unless they are unplugged. Law enforcement has been quick to take advantage of all these technological means to find out what people are up to. Some of these techniques, especially interception of phone and email communications, are strictly regulated by warrant requirements and other special legal rules. But in most states, outside of restrictions that police departments impose on themselves, there are few formal rules governing other types of virtual searches, and those that do exist are very relaxed. A prominent reason for this state of affairs is that, until fairly recently, the courts have concluded that the United States Constitution has little or nothing to say about virtual searches if they focus on activities that occur outside the home or seek information surrendered to third parties such as banks and phone companies. That detached judicial attitude may be in the process of changing. For the time being, however, most virtual searches are not governed by the highest law in the land. Of course, federal, state, and city legislatures need not follow the court's lead. Representative bodies have authority to impose greater limitations than those required by the federal and state constitutions. As the previous discussion illustrates, however, bills that try to do something in this vein often die on the vine due to bickering between civil liberties groups and law enforcement, or obstacles to ascertaining the polity's attitudes toward surveillance. The Nashville hearing in particular makes clear the difficulties in ascertaining what the community thinks about these issues, or even in identifying what the relevant community is and who speaks for it. Nonetheless, if legislatures rather than courts are to be the source of legal regulation for surveillance techniques, then democratic values necessitate some attempt to assess those views. This is especially the case now in the wake of the George Floyd murder, when calls for citizen involvement in constructing rules governing police have intensified. A closely related issue is whether the legislature responsible for regulation should vary depending on the type of virtual technique at issue. It is probable that if Congress were to pass a statute regulating a virtual search technique, such as Senator Klobuchar's genetic privacy law, it would apply across the country because of what is known as the preemption doctrine, which provides that federal law often supersedes state and local law when there is a conflict between the two. The congressional statute requiring a warrant to intercept electronic communications, commonly known as Title III, has precisely that effect. The more important question is whether Congress should exercise its preemption authority. Paul Schwartz argues that preemption by Congress would stymie experimentation in state and local jurisdictions and lead to ossified regulatory structures, given the difficult.
Sample complete. Ready to continue?